what is e-discovery? And this is the subject of our talk, and how can we solve the problem between e-discovery and data protection in the European Union. As you can see in this map, the world is divided into mainly two big legal systems. The blue in the map is the civil law system, and the green on the map is the common law system. The EU countries are part of the civil law system, except for the UK and Ireland. The US is part of the common law system. There are vast differences between the civil law system and the common law system. One of the differences is the civil litigation procedure. In civil law countries, when you have a civil litigation and you sue a person, you go to court with the evidence that you have. If there is one particular piece of evidence that is missing and you know the other party has it, you can request from the other party to produce it. Or if the other party refuses it, you can ask the judge to order the other party to produce that document. In the US, on the other hand, there is an obligation to disclose all the evidence related to the case. So even if the evidence is against you, you have to disclose it to the other party. The parties have the right to request disclosure of all the evidence related to a case. Also in the US, the data protection rights are not as developed as in the EU, but I will come back to that later. So there is a duty to disclose in the US, and it is based on Rule 26 of the Federal Rules of Civil Procedure. For example, if you sue, you use a medication and you get a heart attack, and you're claiming that the company that manufactured the medication is responsible, that the medication caused the heart attack. Then you can request from that company that they should disclose to you all the data that they have related to that medication. For instance, if the medication was put on the market 10 years ago, you can ask for all the emails, all the PowerPoint presentations, all the Excel sheets from 10 years ago until now. Sometimes these are terabytes of data, but they still have to produce it. Now, if let's say you have, somebody has a heart attack and thinks that company X is responsible and sends a letter to company X. I got a heart attack because of your medication. What are you going to do about it? The company can say to itself, oh my gosh, we're going to be sued. Let's quickly delete all the evidence. So together with the duty to disclose, there is a duty in the US, a duty to preserve. It's a common law duty. And when does that duty arise? When does it start? It doesn't start when there is a lawsuit, for obvious reasons, because it would give companies the opportunity to delete the evidence before the lawsuit, when they start thinking that they're going to be sued. So the obligation to preserve data starts when there is a reasonable suspicion that a company is going to be sued. In this case, when they get the letter, they should start preserving the data. How does it in practice, how is it in practice carried out? How is the duty to preserve carried out? In practice, it is carried out through what they call a legal hold. The company has to issue an order to its employees to stop deleting emails, to start preserving all the data that are related to a particular issue. What happens if they don't do that? What happens if a company refuses to produce data? What happens if a company deletes the data and the evidence is lost? And that's called spoliation of data. Well, the sanctions are very serious. The judge can dismiss the case. You can just lose the case because of that. The judge can order punitive and compensatory damages. Or the judge can instruct the jury to make adverse inferences. That means the judge can say to the jury, listen, the data were deleted. You have to assume that these data were incriminating data for the party. I'll give you an example of a case, a very recent case. It was the case of Apple versus Samsung. Apple has sued Samsung in many countries for patent infringement, and they have lost their case in many countries, but in the US they have won. And they, in August 2010, they made a presentation to Samsung about all the patent infringement that they thought Samsung was guilty of. They were looking for a settlement. The settlement didn't happen. So Apple sued Samsung in April 2011. Now, after August 2001, Samsung did issue a litigation hold. But they claimed that their duty to preserve only arose after the lawsuit started. The judge in the US said, no, the duty to preserve started after Apple gave you the presentation, because after that presentation, you should have assumed that you're going to be sued. So you should have preserved all your evidence, which Samsung didn't do. What did Samsung do? They issued a litigation hold, but nobody followed it. They had an automatic email deletion procedure where every 2 weeks all email was being deleted. And even though they issued a litigation hold, the email got deleted. So the court sanctioned Samsung. They sanctioned Samsung. They said, you failed to monitor your employees. You failed to make an audit. You failed to check whether the litigation hold would actually apply. And it was not applied. All the evidence was deleted. So he instructed the jury for an adverse inference. He said to the jury, you have to assume that all the data, all the emails that were deleted had negative information about the patent infringement. And you know what happened in the end. In the end, the judge ended up awarding Apple $1.049 billion in damages. So the sanctions are pretty serious in the US, and the duty to disclose, the duty to preserve are very important parts of litigation. Now, what happens if the company that you are suing has branches overseas? And they may have data that are very important for your lawsuit overseas. Are these US e-discovery obligations applicable overseas? Is there an extraterritorial application? The answer is yes. The courts in the US have decided that as long as a party has possession, custody, or control over the data, that means they have access to the data, they are obligated to produce those data. It does not matter if the data are overseas. They still have the obligation to produce them, and if they don't, they get the sanctions that I mentioned before. Now, the parties that are overseas, the branches of multinationals, the affiliates, they will usually go before the US court and say, wait, what about the Hague Evidence Convention? There is an international convention, a treaty, that both the United States and most European Union member states signed, that says when there is an international request of evidence, it has to go through an official request by the US judge from the authorities in the European Union member states of evidence, and this is how you have to go about it. The US judge can't just issue a court order and with that go to the companies and ask for the evidence. So there wasn't much clarity until 1987 what the law was in the US. Should the judge apply the Hague Convention, or should the judge apply Rule 34 of the Federal Rules of Civil Procedure? Now, the Hague Convention had a lot of trouble because it's a very lengthy procedure. It could, like every bureaucratic procedure, it can take up to a year. Also, some European Union member states and other countries in the world did not ratify the convention. For instance, Belgium never ratified the convention. Also, there is a possibility to exclude e-discovery from the convention and to reserve the convention just for particular documents. Let's say, oh, I want you to produce a contract from September 2002. That is good, that you can use the Hague Convention for, but you cannot use it for massive fishing expeditions like e-discovery. So the Hague Convention wasn't really working for US e-discovery. So in 1987, the Supreme Court decided in a landmark case called Aerospatiale that basically the US judges do not have to go through the Hague Convention. They can just issue a court order based on Article 34 of the Federal Rules of Civil Procedures, and that is enough for lawyers and their representatives, the vendors, to go into any foreign country's company and request all the data. So now, let's say this happens in a European Union member state. There are problems, there are conflicts, because there is the Article 8 Charter of Fundamental Rights of the European Union that protects personal information as a human right. There is the Directive 95 with all the rules and all the member states' data protection laws that protect personal information from being processed and being exported to countries like the US that are not, they do not have adequate data protection according to the EU. But there are other laws like blocking statutes, bank secrecy laws, labor laws, telecom laws, criminal laws. And so the question is, should all these general principles of data protection as far as processing and transferring of personal information be applied in the case of cross-border e-discovery? As I explained before, the sanctions for not producing those data in the US are very real and serious. On the other hand, a company in a member state of the EU also faces serious sanctions from the data protection authorities. If they do produce those data, if they're personal data, and they produce them and they do not produce them according to the rules, they also can get sanctions. So it's a catch-22 situation. A practical solution would be to analyze the case law of the US courts, because each court has decided differently. Some are more lenient. They will be more lenient and accept that there are laws, foreign laws, that prevent production. Some are very strict and they really don't care. They say, we don't care, just produce them, break the law. We don't care. So it's important to analyze the case law, and it's also important to analyze each individual data protection authority's history of sanctions. Some, again, are more lenient than others. So it's really a risk management issue. What is riskier? To produce the data or not to produce the data? Finally, there are two texts, legal texts, that have come out dealing with this issue, giving advice. One is from the European Union. It's the Article 29 Working Party Opinion 158 on pretrial discovery for cross-border civil litigation. And then the next one is a text coming from the US from the Sedona Conference International Principle on Discovery, Disclosure, and Data Protection. Both texts are very authoritative texts. They're texts of scholars, but they are not binding. But they're the only things we have right now to guide us in this issue. So according to the Article 29 Working Party 158 on pretrial discovery for cross-border litigation, all the usual data protection rules have to be followed. I'm not going to go into details because we're running a little bit short of time. We started later. But you can see this on the slides. I also wrote an article about Crossborder Ediscovery. If you're interested and you give me your business card, I will send you the link to the article. But they're very strict. They basically say that you have to just follow all the rules, just like regular data processing of private information, which can be very difficult in litigation. For instance, they say, okay, before you export the data, you have to anonymize it or pseudonymize it. Well, in litigation, it's very hard to prove a case when you have an anonymous email, for instance. So it doesn't really give us such a practical solution. A more practical solution was given by the Sedona Conference, International Principle on Discovery, Disclosure and Data Protection. They came out with 6 principles, which they published last December 2011. I have the text. I can also email it to you if you're interested. They published a protocol, a step-by-step protocol that would, it is not perfect, but it would satisfy both the US judges and the EU data protection authorities. This is it. Jan, my colleague, will now talk about how Deloitte practically applies these principles in their e-discovery practice. Thank you.